Hello again, everyone, and welcome to Quigley on Divorce, a behind-the-scenes look. I'm your host, James Quigley. Thanks again for joining. Today is our third episode of the new year, and you may recall if you've seen episodes 1 and 2 from the start of 2023, that we kind of started the year off with the first podcast, really just introducing the concept in the new year of taking a step, really being action-oriented, right? The idea that New Year's resolutions are great, but you really just have to do something, control what's within your control. We then kind of followed up in the second episode, really kind of dovetailing on that same thing, but taking that general concept and bringing it more specifically as it relates to people who are maybe stuck in a relationship, maybe haven't taken the first step to call a divorce lawyer, to take that action to say, listen, I'm in a relationship that isn't working. The marriage is irretrievably broken. We have tried counseling. We've done retreats. We've talked to our religious clergy. Nothing works. The marriage is over. What do I do? You called Quigley. You got in consultation, and you got things moving, okay? Today, we're going to take the next step, and we'll even follow that up then, or once we get through some of these general discussions, we'll get into some of the specifics of then what really happens as you get into a divorce case. What are some of the issues that you're dealing with? And we'll go issue by issue in some kind of an order, of course, as things happen in our world, which they change, almost daily. I might jump in and interject certain podcast episodes that are really, maybe out of sequence, but I really want to kind of walk you through the process. And we're at the very early stages. And what we've talked about in the first couple is just moving forward. I got to do something positive. I have to get out of this state of inertia. I got to get things moving, and it's got to be in a positive direction. So today I'm talking to you as though you've made that first step. You actually gave me a call, and we had a consultation. So what happens in a consultation? Real simple. I want to understand what the issues are, what brought you to come see me or talk to me in the first place. Probably don't need to get into the level of depth that we may throughout the case. I just need to understand what got you here, okay? And then with that understanding, I'm really trying to make sure, are we moving forward, right? Are you just calling me because, I've been thinking about this for weeks or months or years, and I'm just not sure? Okay, well, that's okay. We have people who do that. They're just not quite ready. What my experience over 30 years tells me is by the time someone calls me or sits down and consults with me, they're ready. They just may not have in their mind fully accepted that, and they just want to think about it a little more for whatever the reason. The wheels are rolling a little bit, but it's rolling pretty slowly, just not ready to take the big plunge. And my experience invariably is that when somebody calls, if they're not ready to move forward, I get a call a week later, a day later, a month later, sometimes it's a year later. But generally speaking, if you're at the point where you understand your marriage is broken down and you're calling to understand what your legal rights are, it's time to move forward in that positive direction. So in that consultation, I'm going to understand where you're at, how you got here. Okay. And that doesn't have to be too involved at this stage. Suffice it to say, I want to check and I want to challenge you as someone calling me to make sure you've exhausted what you can exhaust in your relationship, and that this really is a point in time where you have to go in this direction. All right. In that conversation, too, I need to understand some of the basics of your situation. How long have you been married? Do you have children? How old are the children? Okay. Those simple basics are going to be critical to the case. First and foremost, if you have children, I need to understand if you have minor children, because for me, and how I approach my cases with my clients, children are always the most important thing. I don't care how sophisticated or complicated your finances are going to be, and we can talk about that. The kids have to be the priority to start a case. this is going to have an impact on your children no matter what. If it's mom and dad both agree and we're parting ways peacefully, it's still going to have an impact on your children. If mom and dad really don't agree upon anything and there's going to be this huge fight, that's going to have an impact on your children as well. What I try to do for every client is to try, if possible, to avoid having the children be part of the litigation in any way, shape, or form. Now, I try custody cases, I try relocation cases, and in subsequent episodes, we'll talk more about those type of legal proceedings. So it's not as though every single case you can just say, oh, great, you have kids, let's do what's called an allocation judgment. That is, in the old days, we used to call it a joint parenting agreement or a parenting agreement, different nomenclature these days, but an allocation judgment sets forth everything related to the children. It's a separate standalone agreement. So your marital settlement agreement deals with the financial aspects. Your allocation judgment deals with child-related issues. What's the schedule? What's the holiday schedule? What are the rules with respect to, hey, if mom or dad or a parent is not available at a prescribed time, does the other person get a right of first refusal? By the way, when we get into these allocation judgments, not just the schedule. We have major decisions that we as a divorced couple are going to have to make for our children as they progress through their minority years. What schools are they going to go to? Do we need educational assistance by way of an IEP or tutors? Do we have medical needs for our child, whether they be mental health issues, whether they be physical, your child needs a surgery or something? These are major medical decisions. We have to decide these together. Or maybe one parent has the legal authority to decide those, right? If we have religious differences, how is the child or children going to be raised? Do we have an agreement with respect to that? Is there a fight over one parent has these religious beliefs and the other parent has those religious beliefs, and one wants to raise the child a certain way and the other doesn't? Could be an issue we have to litigate, but we'd like to try to find a way to resolve those by agreement. Of course, children as they grow up, there are all kinds of activities, right? So when you get into who's going to decide what activities the kids are in, how does the activity impact the parenting schedule? Whose responsibility is it? These are all things that we try to figure out. Oftentimes we'll engage a mediator if the parents don't initially agree. But as a starting point in a consultation, I need to understand, hey, do you think you and your spouse are in agreement in terms of where the kids will reside during the week? Is it going to be a 50-50 schedule? Is it going to be that the children are with one parent primarily during the school week for some sort of continuity? Maybe there's some dinners or parenting time during the week, but generally children are staying, with one parent or the other, and then weekends we divide up and vacations and so forth. These are issues I want to just get a baseline understanding of where a potential client thinks the issues are with respect to children. Because if there's going to be a fight, and we hope there's not, but if there's going to be a fight, I want to know about that very early on so we can start to devise an appropriate strategy, okay? And essentially that's what I'm doing in a consultation. I'm listening, I'm getting some of these basic facts, and in my mind I'm starting to understand what the issues are, because doing this as long as I've done this, I've got a pretty good sense of where things are going to go and what you need to do to get there. And that's my job. My job is to take this information, process it, work with my team, put it into a strategy and say, here's what we're going to do. And I make these recommendations. I give this advice to you, the client. Now, some clients don't like that. I was just on a call today, and I rolled out what I thought we needed to do, and it was a very aggressive litigation strategy. And it wasn't going to be comfortable. It wasn't going to be cheap. It wasn't going to be quick. And candidly, my client likely doesn't have the bandwidth. Economically, maybe, but more so emotionally to undertake that type of a process. Completely understandable. I need to know that. If I'm recommending this to accomplish your goal, which is what I'm trying to understand, even in that consultation, where do you want to end up? What is it you're trying to achieve in this process when it's over? Okay? Is it financial independence? Is it primary care of your children? Is it something that's less tangible? I need to understand that, because that way, in the consultation, I can start to formulate the strategy to achieve your goal, and then we reverse engineer coming back, okay? So that's, in the consultation, we're talking about kids. We're also talking briefly about general financial circumstances. Again, I'm not getting deep in the weeds on specifics, okay? I'm trying to identify issues, okay? Hey, my spouse, by the way, has a business. Oh, okay. Are you in the business? Do you work in the business? Do you have access to the financial records? No, I don't know. You know, my spouse provides me with a tax return at the end of the year, and I sign it, but I don't really know. Okay, what's the nature of the business? I need to understand some of these things, because are we going to need a business valuator to come in and value that business? Is it a business which is really just personal goodwill, or is there likely some value to it? I want to understand, too, if there's a business or there's an asset, there's a house, there's whatever the financial issue is, do you, in a consultation, have the ability to tell me, oh, by the way, my spouse owned the house we're living in for 2 years prior to the marriage? Okay, this might be a marital asset, or a non-marital asset, excuse me. And if it's a non-marital asset, was it refinanced during the marriage? Was the other spouse's name put on it? Okay. Was the business started before the marriage? Did the business change into or morph into some other business? How was it capitalized? These are just, again, high-level issue spotting matters that I want to have a conversation about in a consultation. You're not expected to have your balance sheet done. That's going to be the next step. So assuming we go through this consultation and you say, I need to move forward with this process. Okay, I've got a good understanding of what the issues are. Generally speaking, what I like to do then is I like to meet in person. I like to know who you are, okay? We've had a nice conversation on the phone. Maybe it's only 10 minutes, maybe 20, 30 minutes, okay? By the way, generally speaking, I don't charge for a telephone consultation the first time you call me. But if we're saying, okay, I get what your situation is, you understand in talking to me that I can help you achieve your goals in the divorce process. Now we say, let's sit down and let's really start, once you retain me, let's start to devise a formal strategy so that I can manage your expectations, because that's to start at the start of a process. You really need not only a clear strategy, because if you don't know where you're going, you're lost, right? By definition. So we start with, what's our goal? What are we trying to achieve financially, with the children, other issues? You know, what is it you're trying to achieve? We've got now a strategy tailored to your specific case to get you to these various points, all right? And of course, every strategy, it's like going into battle, right? You've got your wartime strategy, but something changes. You got outflanked, something happens. We didn't see that coming. Okay, then we might have to adjust, okay? Let's counter that. And that's what we do. So a strategy is something that we review, we revise, we update as needed based upon real-time developments in a case. But you have to have the experience to be able to do that. But it all still starts with a plan of where we're going, okay? Once hired, too, then we start saying to you, here's some homework for you. 9 out of 10 cases, you're going to have to start with a financial affidavit. Let's get you the financial affidavit. I'm going to connect you with one of the paralegals on my team. Again, we always put a team of people together here at Beermann. And part of why we do that is for just making sure that every client has the individual resources needed for any type of thing that comes up in their case. As the largest family law firm in the city of Chicago, really in the state of Illinois, and I'm not even sure if there's a larger family law firm in the country, but the luxury that affords us for our clients is the bandwidth to handle any matter. Doesn't matter the sophistication, we have the experience in litigating it and managing it, understanding these type of cases. The most complex child-related matters, we've tried these cases, we have the experience, and we have the people and the resources as needed. So if you, an individual, consult with me, you say, Quigley, I want to hire you, and you say, wow, you are an equity partner at the largest divorce and family law firm in the city, your hourly rate's pretty high. I really don't want you to be preparing my financial affidavit. Well, guess what? That's why we have a team. I've got very experienced paralegals. We have tiers of experience that certain things have to be done. We need a financial affidavit. You do not need a 30-year equity partner doing your financial affidavit. What I get is a finished product. And I get to look at that for 15, 20 minutes to say, does there look like there's any aberrations based upon my early discussions with what the case is about? Do I need to talk to my paralegal and say, boy, this number seems awfully high or this number seems awfully low? But I basically get a finished product by really experienced people on my team. That helps save you money, and it's more efficient for me to get to the bottom line. Part of that financial affidavit that the paralegals are going to work with you in creating is a balance sheet. I need to understand, what are the assets, what are the liabilities, what assets do we not have a clear understanding of their value, whether it's real estate, whether it's a business interest. Maybe it's because we don't control the statements and we need to subpoena them, okay? So getting a financial statement, getting a balance sheet together allows us to then initiate the discovery process. And that's really where, when you talk about how the sausage is made, all the stuff that goes into it is really part of the discovery process. It's information gathering. And we have vast tools available to us. Once we have our financial affidavit completed, if I need to send subpoenas to a business, to an entity, to a bank, to a credit card company, I have the legal authority to be able to do that and get that information. If I need to subpoena somebody for their deposition, I have the power to compel them to come in and give a deposition if I need that to get information. If we need to hire one of our private investigators for a particular reason, that's something we do as part of the discovery process. There are interrogatories, which are specific questions that we can have the other spouse answer. And under the Supreme Court rules, they're compelled to do that. A demand for the production of documents. Okay? I'm entitled to ask your spouse for all of his or her documents within reasonably in his or her control. Tax returns, bank statements, profit and loss statements if they're running businesses. By the way, if they own a home and they're claiming they own it before the marriage, I need to see that closing statement. So we as a team will get the information we need to supplement whatever the client coming to us may not know. You're not expected to know everything in a marriage, okay? And it's not uncommon where one spouse in the relationship may be focused on raising the children. And that's sort of been their contribution to this marriage and partnership while the other is out running a business, making money. So maybe someone's not quite as familiar with the finances of the marriage. That's our job. Part of it is to help our client understand the financial reality of their own marriage, because that allows us to then advise the client. Once I have an understanding with my team of what the financial issues are, there's not a lot of nuance to this. There's formulas that dictate child support and maintenance for the most part. You don't see wild swings of the division of the assets. It's not always 50-50. It's equitable distribution, which means it could be 55-45. It could be 60-40, depending on how things go. One of the factors could be someone's non-marital estate. We tried a case. The gentleman had a non-marital business that was given to him by his father, probably worth $75 million. And they didn't have that much compared to the non-marital as part of their marital estate. And so the judge awarded us between 75 and 80% of the marital estate because the other spouse had such vast wealth that was non-marital. It was equitable to give our client more of the marital estate. So there are those cases where you get some shifts like that, but a lot of times once we see the numbers, there's not a lot of need to fight. Sometimes we get in these fights and we're literally fighting over percentage points. 55-45, we want 60-40. Okay, we agree upon 57.5 versus 42.5. And you say, well, why would you even bother doing that? Well, sometimes an extra 5% could be an extra $100,000, or it could be $500,000. So we're always looking at what's equitable, understanding that some people coming out of a marriage and through divorce, one spouse is going to continue on a trajectory of making a lot more money, acquiring more retirement assets, building the value of a business, for example, whereas the other spouse might be in a situation of, this is all I have. I'm going to have a stream of revenue, and I've got these assets. I'm not going to be able to build up my estate after the marriage the way the other spouse is. So it's fair and equitable that I get a little more up front. Okay? That's a general concept. So these are the things that once we get into the actual early stages of, we've had the consultation, you've gotten up, you made the call, we schedule a meeting, you've now hired me, you've engaged me, you've got all the formalities of an engagement agreement. What is that? It's a contract. It says, well, I'm going to perform these services. These are my hourly rates. These are the hourly rates of the people on my team. And this is how it works. It's real money that you spend in a divorce. So if there's a way to avoid litigation, litigation takes time. Time is what we bill. That's where you get charged. So the quicker we can get to a resolution, the less you're going to pay in attorney's fees, whether you hire me or any other divorce lawyer, okay? So always be thinking about that. If you're consulting with a lawyer and the lawyer says, don't worry about it, we're going to make your spouse pay for the attorney's fees, don't be misled, because the person writing the check during a marriage or putting it on a credit card doesn't mean they're paying for it necessarily. Generally speaking, payments to lawyers, even if it's coming from the other spouse, are really just a pre-distribution of your estate. So you're actually paying for it anyway. So the message there, understand from day one, the minute you hire your lawyer, it's costing you money. Every dollar you spend is $1 or 50 cents you're not going to get back as part of your settlement. So always understand, no matter what position you are, no matter what a lawyer tells you about who's paying the fees, you are spending marital money financing a divorce. So pick your battles. It's always one of our mantras. Pick your battles. And we will give you our recommendations as to whether or not this is worth picking your battles. I settled a number of cases at the end of the year. And there were some real tough situations because some of it is emotion-based, right? It's final now. We're actually finalizing this deal, meaning I'm actually going to be divorced. And that's even after all this, I've had some that were 2 years of litigation. And there's still, again, that inertia. I'm kind of paralyzed in the spot. Like, if this ends, if this fight ends and I'm actually divorced, what am I going to be able to do? There's an insecurity in that. And so I had to be very clear and direct with clients in saying to them, hey, the deal we've negotiated in my 30 years of experience is a better deal than I can get you at trial. So you go to trial, it's a double whammy. I don't think you're going to get as good of a deal as we've negotiated from a judge. And number two, you've got to continue to pay me to fight over it. So oftentimes when you get down to that last minute and there's that emotional block, or you say, but, that $15,000, I don't think I should, that should count on my, you say, okay, you're fighting over $15,000. It seems like a lot of money, right? But if you're going to spend $50,000 to try the case in 3 months, over $15,000, it's not logical. And so my job is to interject the cost-benefit analysis into the conversation. So again, this is prepare yourself. Once you make that call, we're now going to have to really dive in. Have a nice call. I understand the issues. Yes, we can help you. A couple of general ideas, but now we need to move forward. You've engaged me, which in turn brings my team into this, and I hand select from my team the attorneys, the paralegals I want to work based upon what type of case it is, right? Sometimes we know from the beginning this is going to be a fight. And I've got certain trial teams. If it's something where, hey, this can be done collaboratively, this can be done through mediation, great. I've got the people on my team that are really well suited in that space with lots of experience, great. We can handle, like I said before, we can handle any situation and we can tailor it to the client's need. But once we're sitting down and we're moving forward, it requires a strategy. It requires rolling up our sleeves and let's say, okay, we got to dive in. We got to start collecting documents. Maybe I have a client that's never really even understood what they have. Well, go home, look in the home office, gather documents, take pictures of documents, take pictures of tax returns, scan us information. Let's start that process because we don't want to rely solely on the other spouse for transparency. A lot of times we don't get that. Subpoenas, a good avenue because banks, institutions, they've got to send us documents. But do as much diligence as you can. And then from there, we go into the next steps. So one of the things that I'm going to do in my next podcast episode is I'm going to go back. And I'm going to start, and I'm going to talk about, even before you get to the point of a divorce, I'm going to talk about prenuptial agreements. Because prenuptial agreements are an effective tool, sometimes very difficult to process, execute, negotiate before marriage. It's not comfortable a lot of times. But sometimes you have a prenuptial agreement. When I'm having that initial consultation, and you say to me, hey, by the way, we signed a prenuptial agreement. Great. Get me a copy of that. Once you retain me, I will analyze that. I'll make sure we understand what your rights and obligations are with respect to that prenuptial agreement. And that might short-circuit the entire process. So on the back end, that's something in a consultation before we really dive in and we got this great strategy, we need to understand, have you waived any rights? Has your spouse waived any rights? Have you guys predetermined certain divisions of assets or income? Okay, so stay tuned. Look for that as our next episode, talking about prenuptial agreements. We've got a lot of thoughts on that, and I think it'll be real interesting for you. In the meantime, again, if you've watched the first couple of podcast episodes and now you've gotten this one and your wheels are moving, it is time, and you're going to make that call to me. We're going to have a consultation, and from there, a formal engagement, and we are going to go to work. And that's when the strategy comes in, get some homework to do, and the case begins, okay? So if you're at that point, you're ready for that consult, give me a call, 312-621-1225 is my direct extension. I'm always happy to give that out. My email address, jmquigley@beermannlaw.com. Beermann, again, 2 E's, 2 N's at end of Beermann. And as always, if you want more information about me, my experience, the firm, www.beermannlaw.com is our website. Thanks again for following along. We got a lot of episodes ahead. This is going to be an active year. We're going to give you a lot of good information. Feel free to, you can always look at our social media, Quigley on Divorce, and DM me with questions or ideas or topics that you might want to know more about if you're not ready to actually call and consult about your specific case. So wish you well. Looking forward to having you follow more and more throughout the year. A lot of information to follow, so take care.